democracy, it's a liberal document, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to put down the rigor of my submission to the extent of saying, I believe that they have a cause, I just don't believe they have a case? I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child. It's not judgment that they place reliance upon extensively. There is a plus and there is perhaps a downside to it. The plus is that judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction, is to read a judgment for what it is not. Secondly, there are only three in places.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millet, I'm sorry. I understand. I'm just placing reliance on this and just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millet. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the two opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here, which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history, is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible.